Tansatoy, I rise today as a Nehiao and Haudenosaunee Esqueo, that means Cree and Mohawk woman of these lands, to speak to Bill 1, the International Agreements Act. I rise as a treaty person from the Michelle Band in Treaty 6 and also for my relatives in Treaty 7 and Treaty 8. I stand in full recognition of the sovereign Indigenous nations whose laws, languages, governance systems, and diplomatic traditions long predate this legislature. Mr. Chair, Bill 1 is not a simple administrative bill. It is not routine. It is not neutral. It is a bill that centralizes power in the Premier's office, cuts off the democratically elected legislature, and bypasses Indigenous nations and their leadership entirely, even though the decisions contemplated under this bill touch directly on lands, waters, resources, policing, education, trade, and intergovernment relations. These are not small matters, Mr. Chair. They are the heart of all treaty matters. And let me remind this government that treaties are not provincial documents. They are, in fact, international agreements. This government knows that, Canada knows that, the Crown knows that, our elders know that, knowledge keepers, nations, and our leaders. In fact, we have never forgotten it. The old people continuously remind us that we must do everything we can to protect our treaties, especially for those babies yet to be born. It is our duty to uphold the agreements of our forefathers made on our behalf. Mr. Chair, elders come together annually for the Elders Treaty Gathering. They come from coast to coast to coast. And year after year, elders assert and remind leadership that treaties are international agreements, not domestic contracts. And furthermore, the United Nations Declaration on the Rights of Indigenous People, which Canada has adopted, is clear. And also, I may note, when Rachel Notley was the Premier, she directed all cabinet ministers to review policies, programs, and legislation to identify where changes were required to align with the United Nations Declaration on the Rights of Indigenous People. This former Premier of Alberta stated that the Government of Alberta must work with Indigenous people in, quote, true partners. My, oh my, Mr. Chair, oh, how this government has regressed and taken multiple steps backwards. In fact, to be clear, this government is so far backwards that First Nations from the Peace region, the Deneta, the Beaver Nation, Tall Cree, Little Red River Cree, and the Duncan First Nations all have lawsuits alleging that this province has failed to uphold treaty obligations. I might add, also wasting taxpayers' dollars fighting in courts because it appears that this government does not know how to govern without infringing on rights and breaking laws. The rule of law is simply that, the rule of law, and First Nations have taken a lead and will not tolerate continued infringements. This government's actions is in such harsh contrast from when the Notley government was in power. The Notley government simply did not just sign the declaration symbolically. They took the approach that implementation should be collaborative, not imposed, and most importantly, aligned with Treaty and Section 35 and the Indigenous legal orders of Treaty 6, 7, and 8. Insofar as Bill 1, this government has completely misstepped and negated to recognize, which the United Nations, I might remind, states very clearly in paragraph 14, quote, the rights affirmed in treaties between states and Indigenous peoples are a matter of international concern, end quote. Mr. Chair, I cannot state it any clearer. Bill 1 disregards the very foundation which upon this province sits upon. So when this government introduces legislation to allow itself to enter international agreements without requiring consultation, without consent, without reference to treaty obligation, it is attempting to rewrite the constitutional and international order upon which Alberta rests. Treaty is not a policy preference. Treaty is the legal foundation of all settlement on this land. And if you remove the foundation, Mr. Chair, the House collapses. Mr. Chair, Bill 1 violates the requirement for free, prior, and informed consent. The United Nations Declaration of the Rights on Indigenous Peoples, Article 19, states that states shall consult and cooperate in good faith with Indigenous peoples to obtain free, prior, and informed consent before adopting legislative measures that may affect them. Bill 1 does not contain a single clause referencing any consultation, not a single clause acknowledging treaty, not a single clause recognizing Indigenous jurisdiction or sovereignty. It is designed to avoid these obligations. This is not an oversight, it is the strategy. This government cannot claim reconciliation in speeches while completely rejecting it in law. You cannot take the part of treaty when it's convenient for you and disregard it when it's not. The Truth and Reconciliation Commission calls to action could not be any clearer. In fact, call to action number 43 states, all governments must fully adopt and implement the United Nations Declaration as the framework for reconciliation. Might I humbly suggest that this government take a look at the outstanding work of the Notley government that they did in this area. The plan is there, the strategy was clear. Collaboration, inclusion, recognition of Section 35, and upholding the rule of law. Mr. Chair, this government continues to contradict principles that have been laid out with absolute clarity. Treaty 6, 7, and 8 are legally binding international agreements that will exist as long as the sun shines, the grass grows, and the rivers flow. And speaking of rivers flowing, oh, I'll wait for debate on debate 7, on Bill 7 for that debate. Mr. Chair, the most terrifying infringement is that Bill 1 is the continuation of the doctrine of discovery, where even the Pope has formally rejected and repudiated the doctrine of discovery back in March of 2023. The Vatican issued an official statement acknowledging that the papal bulls from the 1400s were used to justify colonization, land seizures, and cultural destruction. The Vatican wrote, and I quote, "The Catholic Church rejects those concepts that fail to recognize the inherent human rights of Indigenous peoples," end quote. In addition to this, Mr. Chair, the TRC's calls to action 45, 46, and 47 demand that governments repudiate the doctrine of discovery and terra nullius, the racist ideology that claimed Indigenous lands were empty, that Indigenous law did not exist, and that Indigenous peoples had no jurisdiction. Yet Bill 1 proceeds as though Indigenous peoples do not exist as legal partners. Mr. Chair, that is terra nullius thinking in 2025 in this chamber. It is unacceptable. And I have overheard some members say that treaty is federal jurisdiction, but that's incorrect. The Library of Parliament states both provincial and federal governments share responsibility of upholding treaties in under Section 35 in the honor of their crown. There is no loophole here. There is no passing the responsibility elsewhere. There is no justification for avoidance. Treaty responsibilities bind all levels of Crown authority, including this legislature. Furthermore, the Alberta government has already acknowledged this notion in the Chamber on May 14th in 2025. This government itself amended a legislation to state nothing shall be construed as abrogating or derogating from treaty rights. It would seem that this government already acknowledged that treaty concerns are valid. Treaty rights must be protected. Treaty partners must be respected. Mr. Chair, why the contradiction? Why is a simple, lawful acknowledgement missing from Bill 1? I'll explain it clearly why it's missing. That's because it's the intent of Bill 1. It is to give the province the power to bypass treaty obligations when entering international agreements. That is the breach of the Crown's honour. And I remind this government again, it is unconstitutional. Speaking of constitutionality and legal principles that apply in our country, there is clear precedent set here in our country, the Delgamuukw versus the Columbia case, where the courts remind us that Indigenous oral histories and legal traditions carry equal weight to the written colonial documents. Therefore, treaty is just not text. Treaty is ceremony. It is the pipe. It is sacred. It is a covenant. And it is legally binding as long as the sun shines, the grass grows, and the rivers flow. Lord Denning from the House of Lords also affirmed this. No parliament shall do anything to lessen the worth of these guarantees. The promise must never be broken. Yet, Bill 1 attempts to do exactly that. Mr. Chair, let me be clear. This bill endangers everyone, not just only Indigenous peoples. If Alberta chooses to sever itself from treaty obligations, the question becomes, on what legal basis does this government and all who live here claim occupation on this land? If you remove treaty, you remove the province's legal right to exist. Without treaty, there's no Alberta. Without treaty, settlers are guests without invitations. Without treaty, the province is landless. And I ask every member of this assembly, even those who may disagree with me politically, how will your grandchildren survive on a land where the government has dissolved the very agreements that make the presence of us here lawful? This is not only an Indigenous issue, it's everyone's issue. A better path exists, and we all know it. The government of Alberta has a choice. This government can continue down a path of legal conflict, political division, the erosion of democratic process, or return to the original intent and spirit of treaty. That is, share the land, share the responsibility, share future. Not domination, not centralization of power, not erasure, but rather partnership, respect, and free, prior, and informed consent. This is the only sustainable future. And Mr. Chair, Bill 1 in its current form is undemocratic. It completely sidelines the legislature. It's unconstitutional. It violates Section 35, the honour of the Crown. It's colonial. It attempts to bypass treaty. It's dangerous. It destabilizes the legal foundation of our province. This bill threatens the peace, the good order, and the survival of the place that we all call home. For the sake of future generations, Indigenous, non-Indigenous, this bill must be amended. Mr. Speaker, I would like to put forward an amendment. Oh, sorry.
Have the original. You keep a copy.
Thank you.
Okay, thank you, member. Honourable members, this bill or amendment will be referred to as Amendment A1, and I would ask the member to read the amendment into the record.
Thank you, Mr. Chair. Notice of Amendment, Bill 1, International Agreements Act. Member Calahoo Stonehouse to move Bill 1, International Agreements Act, be amended by adding the following after Section 3. 3.1. For greater certainty, nothing in this Act is to be construed as abrogating or derogating from A, the exclusive legislative authority of the Parliament of Canada with respect to the matters described in Section 91(24) of the Constitution Act 1867, or B, any existing Aboriginal and treaty rights of the Aboriginal peoples of Canada that are recognized and affirmed under Section 35 of the Constitution Act 1982.
You may proceed with your comments.
Thank you. I appreciate your time, and I would urge my fellow colleagues to take time to reflect upon what is at risk if this amendment is not put forward. Hi, hi, Nanaskaman.